I will be serving as the Chief Justice for SCS Event 2024. And this video is for you explaining the procedures that will be occurring in the event United States Supreme Court simulation. Right? So the procedure guide is started with the letter from the executive board. This is for you to read on your own because I cannot really elaborate on this alone. So starting with the procedures. So um, most of us here would probably be going to school, right? So what is the first thing that happens when you go to school? It is attendance, right? So in the same way, the committee will be having a attendance. If you are present in the committee, say present when the executive board or the judges call out your name. From the people who are here from United Nations MUNs, there is nothing such as present and voting. There is only present. So say present only if you are there in the committee. And if someone is not there, you do not need to call out absent. The executive board will say their name twice. If they're not there, do not respond twice. They will automatically mark absent. And if you join later, it is your responsibility to inform the executive board of your presence now. Alright? So, the stemming from these procedures is from the actual United States Supreme Court. Right? But for the sake of competition purposes, some elements have been added to make this a competition because it is not really possible for these people to compete. But since this is an event and a competition too, that's why we have some procedures that have been modified in a way such that everyone gets equal participation. So, where do we stand? We stand at a spot where the United States Supreme Court has decided to have oral hearings on the Supreme Court case, that is, United States of America, the petitioner, versus Donald Trump, the respondent. Alright? So, first, after the attendance, we will take the argument from the petitioner, that is United States. The first attorney will get up and lay out the opening statement from United States side. He or she will have 2 minutes to lay out this argument, 120 seconds. Alright? So, after the statement, two questions will be asked to that attorney. The first question from me, the Chief Justice, that is me, and the second question from RF sir, that is the judge number 2. Alright? So, you will have 30 seconds to reply to each of the questions. Every reply to the oral question you have will be marked absolutely. Alright? So if you did 0.5 on one and 0.7 on other, you will be marked in total 1.2. For example, I'm not telling you what is the marking scheme and how much it is being marked off, but you'll get 1.2 as a total, not 0.6. Alright? So try to answer as much as you can because it's better than letting a zero by not answering. Now, the committee, after having this first statement from the petitioner side, will automatically move into a statement from the defense side. Now, the defense side will have the same procedures as the petitioner side. 2 minutes to present the argument, 2 questions from each of the 2 judges, and then 30 seconds to answer each of them. Alright? Again, this will be marked absolutely. Now, this will be done for all the 3 lawyers from both the sides. So, 6 lawyers will present their statements, and the judges will ask 2 questions to each. Before that, a certain thing that you have observed while seeing those cases is the number of objections that are raised. So, in this simulation, we have also decided to include the system of objections. Now, first thing I want to clear this. If you raise an objection, you will not get marks. If you raise an objection and the objection is sustained, the person who the objection was against will get down mark. Down mark is basically if they were getting like 5 on their speech. Now they will get a 4. These numbers are again random numbers. Don't go to them by heart. Right? So, the attorney is giving the opening statement. There are 3 lawyers on the other side. Each of the 3 lawyers has 1 chance at every speech to raise objection. Objections are split into 4 types. Objection hearsay. Hearsay is basically when you are quoting a statement by someone who is not present in court. For example, you say that Donald Trump said to his wife on this date at this time at this. Unless you can provide valid evidence that this is the audio clip or this is the video clip of Donald Trump saying that, this cannot be used as evidence in court. So the other side, observing that the lawyer is talking about Donald Trump and his wife talking, can say objection hearsay, OHS, right? And the judge will probably sustain it because there is no actual evidence that is sustained to the argument. It is hearsay. That is in Hindi, boli wali baat. Next objection we have is objection lack of foundation. When the other attorney is saying something that is completely ridiculous, then is objection lack of foundation. Lack of foundation basically means that the argument is there, the evidence is there, but the basic logic does not stand to. Alright? Objection irrelevance, irrelevant matter discuss हो रहा है. Objection lack of evidence, there is no evidence in what the person is saying, and it is just accusations. Alright? So, if the person is giving a speech, you then unmute yourself and say the store word, the acronym of the objection. So, if, for example, Donald Trump's attorney is saying that at this time Joe Biden had made a statement about OHS. So, objection here say the judge will automatically note it down. Mute yourself right after you give the objection. The judge will reply to you sustained or overruled, where sustained means the objection is in order and the person the objection was raised on will be then down marked, and overruled means that the objection is not in order, objection was wrong. Alright? So during the opening statements from the attorneys, the floor is always open from chits or point of interjection chits from the witnesses present in the committee. So this will be the format for the witnesses to send chits. So moving on to how does a court get its stem in argument from? We are in the United States Supreme Court, and the Supreme Court is a very busy court. So Supreme Court usually does not have enough time to actually bring witnesses himself. But again, for the sake of the competition, we have witnesses in this court, and Supreme Court will be taking and listening to what all of them have to say. So after all the speeches are done from the attorneys, we will move to motions to bring witnesses to stand. Alright? So witnesses can be called upon in a random order, while we will prefer the people raising their hands to go first. Alright? So you raise your hand if you are a witness, and we will recognize you, and then you will give your witness statement. Now, how does a witness statement work? You will have 60 seconds to speak to the court. Alright? And give the statement and argument, whatever you have, whatever you want to say about the topic. Alright? The executive board will then let two POIs happen. First POI will be from the defense side, and the other will be from the prosecution side. The order might differ on basis of who we think brought the witness in front of the court. Alright? So the people who are asking the point of interjection, or the lawyers that are asking the point of interjections orally, will get 20 seconds to ask the question, while the person answering, or the witness, will get 30 seconds to answer each question. Alright? So after this, after the two POIs from the attorneys, if there is a need, that is your speeches and the POI content, the POI question was very invaluable and you can't really say anything about it, then the judge will also ask you a POI to make sure that you have an equal standing in the marks. Alright? So this will be repeated for every witness that is present in the committee. During the witness statements, any lawyer that and all the statements beside this, all the witnesses beside the witness that is speaking, then send POI chits on whatever the person is saying. The POI chits will be tapped at 10 per participant, and they have a very high weightage. They are almost being marked on par level with your verbatim. So make sure you utilize the chits as much as you can. Alright? So 10 chits is the maximum amount you can send, which is not inclusive of reply chits, of course. Right? So POI chits are marked absolute, and POI replies are marked average. Right? This is the format for a POI question 1. This is a POI reply chit. Make sure you utilize it to the max. Right. So getting on to the points that will be valid, if there is anyone from UN committees, they will know this. A point of personal privilege is basically when you have a query, you want a repetition, or you cannot hear someone. That is a point of personal privilege. A point of inquiry is when you have a procedural doubt from the executive board, like what will happen next, is the witness allowed to say this, what is a document, how to send a POI chit. These are questions to the executive boards about the procedure. While point of personal privilege is personal discomfort. Alright? Moving on to what happens after the witness testimonies in the simulation. While it is true that in the United States Supreme Court, there is nothing like open debate, but for the matter of again fun and competition, we have included a special thing, that is open debate, where it requires 50% plus 1 of the committee to vote for it. If the motion is passed, the committee will move into open debate, and I highly suggest that you should have open debate. Open debate is what is the tiller argument, what makes one win, another lose. Alright? So, witnesses and attorneys can decide on this time to that understanding of what the other people have to say. You can be recognized more than once and for any number of times. Alright? Every time you get recognized, you will have exactly 20 seconds to say whatever you want. Alright? So after 20 minutes have elapsed, minimum of 20 minutes in open debate have elapsed, you then move into motion to deliver final say. If this motion passes, like the open debate is broken, the committee will move into final statement procedures. Right? If the motion fails, then the committee will have to continue open debate. It is no restriction that motion was just raised in the last speech. Can I raise a motion again? Yes, you can, but try to understand why people failed the motion. Alright? So, open debate can also be broken by the decision of the institute board. I have not written it, but in case there is a scenario where your guys are for some reason not breaking open debate, the executive board will do it for you. Now, what happens after open debate? Like opening statements, we have final statements. So, every person in the committee will have 1 minute to deliver their final stance. Final thinking that this should be done. Be clear on what you want to do. Do you want the prosecution to win? Do you want, petition side to win? Do you want the respondent side to win? Make sure to include all that you can. You will have exactly 1 minute. If your time is left, that is maximum time is 1 minute, but if you use less time, first of all, you have a mandatory POI. You have to take the POI regardless of how much time is left. Right? So if you have, for example, 4 seconds left, you can take 2 POIs. If you have 8 seconds left, you can take 3 POIs and so on. But if you have, say, 16 seconds left, that is the maximum amount. If you have 16 seconds left or 50 seconds left, you can take up to 5 POIs, no more than 5 POIs. Alright? So I'll try to suggest that do not yield anything more than 12 seconds, but the maximum you can yield is 16 seconds. Right. So after the final statements wherein everyone has spoken, the floor for the chits closes. That is the last chit you can send is on the final statement of the last person. After the final statements, we will again move into something that is not present in the real Supreme Court. That is the judgment documentation. When we talk about the real judgment of the United States Supreme Court, it comes on form of 2 parts, arbiter and ratio dissenting. But they are not clearly explained that what is the arbiter, what is the opinion, and what is the ratio dissenting. That is the part that is to be executed. So, to make this committee a little more simpler for the people attending for the first time, we have made it so that you already have a predefined format for a judgment document. Wherein this is the format. You will have 4 parts to this document. Why should the document be accepted? Reason 1, reason 2, reason 3. The charges that against Donald Trump have been accepted. Charge 1, charge 2, charge 3. The charges that you lack evidence and are acquitted. Acquitted means let him go. Donald Trump for. Charge 1, charge 2, charge 3. Make sure you at least have 2 on each. And last is, the court concludes that Donald Trump cannot do the following. See that? So these 3 or more things will be things that Donald Trump cannot do. For example, if you reach a conclusion that is Donald Trump actually did the insurrection, then you then add a charge that Donald Trump now cannot compete in elections or something. I'll simply tell you now, the more the number of points, the higher it is a chance for your document to be passed into the video. Correct? Now, moving ahead with the procedures. You will submit a judgment documentation in groups of 1 to 3. 1 minimum, 3 maximum. You must have the document in line with what you said in your final statement. Alright? The executive board will choose every one of the judgment documentation that are submitted. Alright? So, basically the judges will mark you on a tier list from, let's say there are 7 documents submitted. So, judge will mark you on a tier list from 7th, 6th, 5th, 4th, 3rd, 2nd, 1st. Where the first one gets the maximum marks and the 7th one gets the least amount of marks. Alright? So, if there is a scenario wherein 2 documents have very same resemblance, they are almost the same and are probably on the same rank in the tier list, then the document with less number of people will get preference. Because 3 people could make content that was qualified to comparatively 2 people in the committee. So 3 people should have done more, but 2 people were about to do the same. So 2 people will be preferred. Now, moving into the concept that is, once the best document submitted has been adopted by the court, it will be opened for amendments. There will be three type of amendments: addition, add some lines; deletion, remove some lines; updation, update some lines. Clear as it is. Now, how do your amendments get passed? First thing I want to clarify: amendments are marked and they are worth a lot of marks in case your judgment documentation is very bad. If you are amended, you will get a lot of marks. Now, the amendments are marked, so accepted through two ways. The first way is the friendly way. The friendly way is when all the authors of the judgment documentation agree to the amendment. This is the easier way. The unfriendly way is that the committee attains a simple majority, that is 50% plus 1, and decides to let the amendment added to the document. Alright? So that will be it. Once these amendments are done, the committee and the executive board, the judge panel, will adopt the document with the amendments as the final verdict of the decision that took place in United States Supreme Court in the case of USA versus Trump. Once I, the Chief Justice, formally announces the adoption of the judgment document, the court is automatically formally adjourned. Right? So this is all the procedures that is there for SCS Event 2024 to be held on 19th on Sunday. If you have any doubts, you can reach out to me personally on WhatsApp. Uh, in the scenario that we have a training session today, you can ask your doubts in the training session itself. This shall stand as the guide for the procedures that shall be uttered. It has almost everything highlighted. If you are unable to understand something on the day of the conference, the executive board and the judge panel is here to help you out at the same time. So yeah, that's about it. And this is Ikshit signing off. And this is all the procedures to SCS Event 24. Thank you.